You're James Brown appearing there from the jail?
Yes.
All right, we have two cases involving Mr. Brown. First one, Mr. Brown is appearing from the Justice Center by Zoom. His attorney is William Armentrout, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. In case number 23-CR-189, a defendant is indicted for forgery and theft by deception, both fifth-degree felonies, and the case was issued for his arrest for his failure to appear, and he was taken into custody. And so the matter on that one would be bond. And Mr. King, has the alleged victim of the offense has been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, and they've elected not to appear this morning.
All right. Well, there also is a new indictment in this case, and in a new case, case number 24-CR-007, in which Mr. Brown was indicted earlier this week, I guess it would have been on Tuesday, for failure to appear. Mr. Brown has filled out the financial disclosure form, and everything on this form is correct, Mr. Brown?
Yes.
All right. And Mr. Armentrout, you're aware of this new indictment?
I'm aware of it, Your Honor. I've not seen it.
All right. Do you wish to have the indictment read? For failure to appear at the last hearing that was set in the 189 case.
I'm sorry, Judge, I didn't hear the first part of your statement.
It is failure to appear in case number 23-CR-189 on December 13th.
December 13th, okay.
All right.
We'll waive the reading of the new indictment and enter plea of not guilty.
All right. And for the record, the court does appoint Mr. Armentrout to represent the defendant. All right. Now, I'm going to since the failure to appear is related to the 189 case, and the law on that is that failure to appear flight can be considered as evidence. I think they can be tried together. If you wish to file a motion to sever, then the court would address that, Mr. Armentrout. But I'm going to go ahead right now and set both of these together. I'll set a final pretrial for January 17th. Final pretrial for both cases. There won't be a first pretrial in the new case. And trial will be set for February the 12th at 8 a.m. The final pretrial time will be 1 p.m. Now, state wish to be heard on the matter of bond in these two cases.
Yes, Your Honor. I'll start with the 23-CR-189 case. The state would ask that the defendant's OR bond be revoked and the bond be set in the amount of $5,000. This defendant repeatedly misses court. In the 189 case, he's missed court on 3 separate occasions. He has another instance, he arrived approximately 45 minutes late. The state would also ask in the 24-CR-07 case that bond be set in the amount of $5,000. It's my understanding this defendant repeatedly claims he has medical issues and doctor's appointments, surgery scheduled. To my knowledge, no proof of any of this has ever been produced. At least if it has, I've never seen it. So I think at this point, a $5,000 bond in each case is necessary to ensure his appearance in future proceedings. Thank you.
Mr. Armentrout.
I don't know that my client has the ability to make any kind of bond. I'm sure that he can't make a $10,000 bond. He possibly could make a $5,000 bond. He has indicated to me that he is currently under dialysis. I would think that could be easily verified. The court set some kind of minimal bond in both these matters. He does have a place to reside, Your Honor.
Well, the problem is Mr. Brown just doesn't show when he's supposed to. He comes up with all these medical excuses, but he never provides us any proof of any treatment. And calls in at the last minute and claims, for instance, the last call I recall my assistant said it was that he was supposed to have a 7-hour surgery, I think Monday, and then I think he got arrested on Tuesday. So, clearly, there's been a problem. So if he would provide some proof of something, then, that would have Mr. Brown, you be quiet. I've given you your chance repeatedly in the past, and I told you last time I was tired of it, and I wasn't going to put up with it. And this is, the roosters, the chickens have come home to roost, and I'm tired of listening to your excuses. You put up or you shut up. If you've got proof, you get it to your attorney, and then we'll deal with it. But until then, I don't want to hear a word from you. Now, bond will be set in the amount of $5,000 plus $171 service fee in each deposit in each case, and all the original orders that were previously issued in 189 will also apply in 07, including pretrial supervision, which Mr. Brown's not been complying with either, reporting. And so that'll be the order of the court. All right, thank you.
Okay.
All right, the next one is actually, they're not scheduled till 8:30. Okay, we're ahead of schedule. That's okay. All right. But we'll go ahead and tell her to call, see if they can get them logged in so we get done early. All right. And there's the Brown cases. Let's see. Wait a minute. Where's the other one? Here we go. No, that's Witt. There's 2 Brown cases. Oh, here it is. Yeah. All right. Are you Christopher Jalani appearing there from the jail?
Yes, Your Honor.
All right. This is case number 23 CR 232. State of Ohio versus Christopher Jalani. This is a bond review. Mr. Jalani was arraigned, I think on Wednesday, on charges of retaliation, harassment with bodily substance, and criminal damage. The state's represented by Assistant Prosecutor King, defendant's represented by William Armentrout, and this is hearing is being conducted by Zoom. The defendant's appearing from the jail. Mr. King, has the alleged victim of the offense has been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor. All alleged victims have been notified, and they've elected not to appear this morning.
All right. Mr. Armentrout, you wish to be heard on the matter of the bond?
Your Honor, I don't believe Chris has any prior felonies. I represented him on a misdemeanor recently in the municipal court that was, I think, 2 or 3 hearings by the time we got it resolved. He appeared every time. I don't know if there's any favors of appear. I've not seen any notice of that. I don't want to demean the seriousness of these charges, Your Honor, but I did represent him when this matter was bound over from the municipal court. But let me just say, I've seen these charges before at a lot more serious level. I know that doesn't mean anything as to whether he would appear for hearings, but he has a place to live. I think he still has employment he can go to. We'd ask the court to consider an OR bond in this matter.
All right, Mr. King, on behalf of the state.
Thank you, Your Honor. The state would ask that the current bond remain in place. I don't believe this defendant has any prior felony convictions. However, I would just note for the court, it's my understanding he's currently serving a 90-day sentence out of municipal court for a probation violation. And also this morning I was checking the records on municipal court's website. He did have a prior theft conviction out of that court, and it looked like he failed to appear for review hearings on 3 separate occasions. So based upon that, I would ask that the current bond remain. Thank you.
All right, yeah, I do believe Mr. Jalani is serving a sentence out of municipal court anyway, so at this point, I'm going to leave the bond in place that was originally ordered $10,000. If something should change with the other sentence, then court you could file another motion and court would then review it at that time. All right, thank you. Excuse me. All right, are you Durant Peters appearing there from the jail?
Yes, sir.
All right, this case number 23 CR 235, State of Ohio versus Durant Peters. This is a bond review hearing. Mr. Peters was arraigned Wednesday in the absence of counsel. The court entered a not guilty plea and set the matter for a review pursuant to the statute. He was indicted for felonious assault, abduction, and domestic violence. His attorney is Catherine Hapner, appearing from her office by Zoom, appearing from the prosecutor's office by Zoom is Assistant Prosecutor King. Mr. King, has the alleged victim or victims of the offenses been notified of the time, place, purpose of this hearing, the right to be heard?
Yes, Your Honor. She's elected not to be present this morning.
All right, thank you. All right, bond was set in the amount of $50,000 on Wednesday. So, Ms. Hapner, would you like to address that matter?
Thank you, Your Honor. Your Honor, I've been acquainted with Mr. Peters for a number of years. I've represented him before in Washington Courthouse. He has, to my recollection, always appeared at all of his hearings, and I am actually quite surprised by these charges. Mr. Peters, I think, would be quite upfront with you and honest about the fact that he's had a drug problem, but he's never had any issues with violence. He does have a place to live in Washington Courthouse, and we would ask that his bond be reduced so that he would have the opportunity to be released.
Mr. King?
Thank you, Your Honor. The state would ask that the current bond remain in place. From a quick check prior to the start of this hearing, it looks like the defendant has, from what I can tell, 5 prior felony convictions, including a prior attempted burglary conviction. Also has misdemeanor convictions for domestic violence and violating protection order. So given his criminal history, along with the nature of the pending charges, the state would ask $50,000 bond remain in place. Thank you.
All right. The court has access to other court records through the Ohio Court Network, and according to this, it was at least in 2015 a failure to appear on an OR bond and a misdemeanor. And I do believe that what Mr. King indicated regarding the previous convictions appears to be the same as what is in my report. Given the serious nature of the offenses and the prior history of domestic violence, excuse me, the court is going to leave the bond the same. All right. Your attorney will be in touch with you, Mr. Peters. Thank you.
Yes.
All right. All right, this is case number 20 CR 151. State of Ohio versus Shanda Jones. You're Shanda Jones appearing there from the jail?
Yes.
All right, this is a bond review hearing. The defendant was arraigned Wednesday. Counsel was appointed, and in the absence of counsel, court set bail and then set the matter for review. She was charged with escape and grand theft of motor vehicle. Her attorney is Danielle Witt, appearing from her office by Zoom. Appearing from the prosecutor's office is Adam King, assistant prosecutor. Mr. King is the alleged victim of count 2. Been notified of the time, place, purpose of this hearing, the right to be heard.
Yes, Your Honor, he's elected not to appear this morning.
All right. Bond was set by the court. Well, I'm trying to find my arraignment entry. Well, oh, here it is. Got separated from the file. All right, bond was set in the amount of $15,000. Ms. Witt, would you like to address the matter of bond?
Yes, Your Honor, we do ask for a reduction in bond. Just from a quick search, I did not see any criminal history in this court, and it appears that this is an older case and that she has ties to the community and resides in Leesburg.
Mr. King?
Thank you, Your Honor. The state would ask that the current bond remain in place. Just to note a couple things. First off, there's been a warrant in this case for the defendant's arrest since August of 2020. It appears she does have, at least from what I can tell, 4 prior felony convictions. And in fact, just last month, she was convicted in Fayette County Common Pleas Court of possession of heroin and failure to appear. And now we have an escape charge pending here. So given all that, I do feel the current bond is appropriate and necessary. Thank you.
All right, well, clearly, count 1, the escape charge, is one is very concerning to the court. The fact that this is a 3-year-old case and going on 4, and the defendant was indicted back in August of 2020, so it's over 3 years old. It was actually a bind-over, and apparently the escape charge is alleged to have happened after that. The court also notes in the court report from the Ohio Court Network that there was a bond or a failure to appear on an OR bond out of Fayette County in August of last year. And then looking at the Court Network report, I see failure to appear in July of 2016 on both an OR bond and on a summons for misdemeanor. And so based upon that, the bond will remain the same. All right. And your attorney will be in touch with you, Mr. Jones. Thank you. All right, we're ready for Mr. Wenga. All right, are you Allan W. Wenga appearing there from the jail?
Yes, sir.
All right, just case number 23 CR 235, State of Ohio versus Allan Wenga. This is a bond review hearing. Mr. Wenga is appearing by Zoom from the jail. His attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office, Assistant Prosecutor King. The defendant's been indicted on charge of strangulation and domestic violence. The court arraigned him on Wednesday and set bond in the absence of counsel, and therefore pursuant to statute, courts are conducting this bond review. Ms. Witt.
Yes, Your Honor. And, we do ask for a reduction in bond from a quick search again. Did not see any history in this court, and I didn't see any previous domestic violence charges in this court either. and he does reside in Hillsborough, according to this court's website.
Mr. King?
Thank you, Your Honor. Given the nature of the pending charges, the state would ask that the current bond remain in place. If I recall correctly, during the arraignment on Wednesday, when the defendant was asked where he would be residing if he posted bond, he was not able to produce an address. I suspect that is because where he had been living prior to this offense was the residence he shared with the alleged victim in this case. So based upon all that, the state would ask that the current bond remain. That's all, Your Honor. Thank you.
As I do recall that as well, at the arraignment, Mr. Wenga didn't have a residence established. He could not go back to the residence where the alleged victims living. So, and again, due to the nature of the offense, even though there is no prior record, given the fact the defendant has no established residence to go to, and the nature of these offenses, the court's going to leave bond the same. Now, that'll be subject to review if further information becomes available. All right, thank you. I think that's it then, Dan?
Yes, Your Honor.
All right, thank you, everyone.
Thank you.
All right. All right, good morning. Let's see, Mr. Baker, Mr. Doyle, if you would start your video and activate your audio, please.
Thank you, sir.
All right, this is a case in Brown County Common Pleas Court, Domestic Relations Division, Tanya Doyle versus M. Richard Doyle, case number DR 20140326. The the matter before the court is a motion for a review of the sentence that the court imposed for contempt, multiple contempts against the plaintiff, Tanya L. Doyle. Now, Ms. Doyle's attorney is appearing by Zoom, Mr. Baker, and Mr. Doyle is appearing as well. And Ms. Doyle, I believe, is currently incarcerated. Is that correct, Mr. Baker?
It is, Your Honor.
All right. All right. Well, I received the motion. I know she reported to jail on the 2nd. The motion was filed on the 3rd. And I guess the question, the reason I set this for a hearing is, you know, there was an indication of some willingness to try to do something to make up for the past visitation that was denied, for which the court imposed a contempt sentence. As the court noted in the decision, since the children are now over 18, the court doesn't have any ability to enforce any visitation, and it would have to be totally voluntary. And according to what I see in your motion, that hasn't been done. Has there been any attempt at communication, Mr. Doyle, from the plaintiff?
No, Your Honor, it's been nothing but manipulation. In fact,
Well, I just asked for communication, not an opinion. All right.
Yeah, none.
And so, you know, Mr. Baker, the court's position is that if you want to present some sort of a proposition to Mr. Mr. Doyle regarding, you know, establishing some sort of parenting time for him to have some time with these children, since she's in jail, I assume that they're in the care of someone else. You know, I'm not going to negotiate that. If you want to negotiate with him, that's fine. I think you said there was some issue about getting in contact with him. And let's see, what is that tool that the court uses down there for parties?
Our family wizard, but we don't use that anymore.
Okay.
She knows my phone number. It hasn't changed in 36 years. And he knows my email.
All right.
It's been in every filing.
All right. Well, Mr. Baker, if you want to negotiate with Mr. Doyle, you know, certainly can do that. But, you know, the contempt that was imposed, there was no purge because, you know, there's no ability to purge. And anything that would be done would be strictly voluntarily at this point. If that happens, then the court would, you know, consider a reduction of the jail sentence. If Mr. Doyle, in fact, gets parenting time, the court would consider at that time. But at this point, I'm not going to make any changes. You know, I'm a little disappointed that nothing's happened up till this point, that you waited until the motion was filed. But, you know, I think the record is clear that her history has been persistent, ongoing, and deliberate, and you know, there has to be accountability for that. Again, I'm willing to consider reducing the jail sentence. You know, it wouldn't go away completely, but it would, you know, I would consider doing that. But there would have to be some sort of an agreement between your client and Mr. Doyle. So, as her attorney, I assume you would have you could meet with her and get authority from her of what you could do, and then email Mr. Doyle in that way and negotiate with him that way. So, but for the time being, the court is denying the motion for a stay. And again, as I indicated, the new information comes up, then I'd be willing to consider a reduction. But, you know, at this point, you know, I made my decision, and you know, and I'm not going to change that unless there is some significant parenting time that Mr. Doyle is agreeable with that would, you know, warrant a reduction in the sentence.
May I ask a question, Your Honor? Because I have not seen or talked to my children since the second they turned 18. Where are they?
I have no clue, Mr. I don't know, Mr. Doyle. You'd have to communicate with them as well. I have no clue. I don't know, and I'm not. That's not the purpose of this hearing. So, you know, if you want to if you want to reach out to Mr. Baker, you have his email, I assume. You can do that, and the two of you can discuss the matter as to what might happen.
One last question. Is there, since I have a CPO that was definitely unwarranted, and I'm going through a 60B now, on that. Do I just keep going indefinitely without seeing my children? Because it's an unlawful restraint situation. They're trapped. They
Okay,
can't-
well, you're asking me for legal advice, but let me tell you this. You know, as I indicated, I have no authority to order any kind of visitation now because your children are 18,
Right.
and so I have no authority. And so, you know, that's something I can't advise you on.
Mike.
And the CPO doesn't have anything to do with this court, with this case.
Well-
So don't ask me any more questions about that because I can't give you any answers. All right?
Okay.
Is there anything else you'd like to ask about this particular motion? Because that's the only thing that's before the court.
will
I'm
she
not here
stay in
to
jail?
review your case.
Will she stay in jail now until Mr. Baker and I either do or don't come to an agreement?
She's going to serve the sentence unless something comes back before me that warrants a reduction, in my view, based upon the presentation, part of which would be some sort of an agreement, I think, between the two
Okay.
parties. But again, I can't say what that's going to be. I don't have any authority to impose that. Any kind of a visitation arrangement would have to be voluntary on her part because I have no authority to do anything about that. So you would have the right to seek a guardianship, I suppose, if you wish to do something like that, but that's on you. That's a different case at a different court. Has nothing to do in this case, in this court. Okay?
I did see in the docket that there was also.
Okay, I'm done with you, Mr. Doyle. I'm not here to answer 40
Okay.
questions. I was here, I've made my decision, and I've given you the instructions.
Yes, sir.
If you have other questions, you'll need to investigate and obtain answers for yourself.
Thank
All right,
you. I'm
thank you.
very grateful. You did an amazing job.
Thank you.
I'm extremely grateful.
All right, well, thank you. All right.
Okay. Mr. Baker, you have my phone number.
Okay. So, Mr. Baker, if you want to reach out to him, you can do so. I'm going to go ahead and end the hearing then. Thank you.
Okay, thank you.
Jesus. This is case number 23 CR 193, State of Ohio versus Travis James Zuber. This is a hearing that's being conducted by Zoom. And are you Travis James Zuber appearing on the screen, marked Travis Zuber? Mr. Zuber is frozen up.
Your Honor, that appears to be like a still photo. That's not actually Mr. Zuber live.
Oh, okay. Well, he just went off. Can you text him, Mr. McMullen, to tell him to sign back in?
Yes, and I think he's also going to have to call in. He had to do that last time we were on Zoom, Your Honor.
Okay. Well, for the record, Mr. Zuber's attorney, Justin McMullen, is appearing by Zoom from his office and also appearing from Prosecutor's Office, Assistant Prosecutor King. So we'll take a moment here. All right, there's a call coming back in here.
There he is.
All right, there we go. All right. And you are Travis Zuber there on the screen, marked Travis Zuber?
Yes, sir.
All right. And I don't know, who is the person on the 419 phone?
That might be me as well.
Oh, okay. Called in on phone. Okay.
That's how I dialed it.
Gotcha. All right. All right. So this is a hearing that was set for a plea, and I have a proposed plea form here. Now, Mr. McMullen, are you and your client both in agreement that this matter can be conducted remotely by Zoom in lieu of a personal appearance in the courtroom?
We are, Your Honor.
And you're all right with that, Mr. Zuber?
Yes, sir, I am.
Now, in the event that you need to talk to your attorney during this hearing, since you're not seated next to him, you let me know, and I can put the two of you into what's called a breakout room, in which it'll be just you and him on the screen, and no one else will be able to see you or hear you, okay?
Yes, sir.
All right. So, Mr. Zuber is indicted along with a co-defendant. In count one, he's charged with engaging in a pattern of corrupt activity, and then looks like he's charged in counts 25 and 26, trafficking and possession of hashish, and then a forfeiture in count 32. All right, now I have received a faxed plea form, Mr. Zuber, which is a form that the prosecutor's office prepares for plea hearings. And I'm going to show you the first page, and it has the case number and the name and plea of guilty form on it. So I'm going to hold that up to the camera. And do you recognize that page?
Yes, sir, I do.
By the way, the big screen's not working. Have we got to call into Javs?
It's back on.
Oh, okay.
Yeah, it's jumping around.
Okay. All right, now on page 3, Mr. Zuber, about halfway down the page, there's a sentence that reads, I enter this plea voluntarily, and immediately below that appears to be the signature of Travis Zuber on a line under which is printed signature defendant. Now I see a copy of your attorney's signature and then the original signature of the prosecutor. I'm going to hold that up to the screen and ask you if you recognize that signature there.
Yes, sir, that's my signature.
All right. When did you sign this document, Mr. Zuber?
I signed it yesterday afternoon, approximately 14:30.
All right. And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And before you signed it, did you go over it with your attorney and discuss it with him and have him explain things to you and answer any questions that you had?
Yes, sir.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir, I did.
And did you enter into this agreement voluntarily?
Yes, sir, I did.
And are you still wanting to go forward with it today, a day later?
Yes, sir.
All right. Now, the agreement states on page 1 that the state is going to reduce the charge to possession of hashish, a third-degree felony, in count 32. Currently, wait a minute, count 26, I'm sorry. Currently, count 26, possession of hashish, is a second-degree felony due to the amount of the substance that is involved. And that means it carries a sentence of 2 to 8 years as a minimum, up to a maximum of half of the term imposed by the judge. I should say 2 to 8 years as a minimum as set by the judge, up to a maximum of half of that term that is ordered by the judge being added by the Department of Corrections, and a fine of $15,000. Now, by amending it to reduce it to a third-degree felony, that changes it, the possible penalty, to 9 to 36 months. And it goes in increments. It starts at 9, then goes to 12, and then goes every 6 months up to 36-month maximum, and a fine of $10,000. And there's also a license suspension of 6 months to 5 years, which is also applicable for a second-degree felony. Now, do you understand that amended, the sentence for that amended charge?
Yes, sir.
All right. Now, there is a presumption under the statute that a prison term is necessary, but it's not mandatory. And so the court has the discretion as to whether or not to sentence somebody to prison or to put them on probation or community control. Do you understand that?
Yes, sir.
Now, are you facing any felony charges anywhere else, Mr. Zuber?
No, sir, I'm not.
Are you currently on probation, parole, community control, post-release control, or probation for a felony?
No, sir, just the current bond release terms.
All right. Now, under the law, Mr. Zuber, if you're convicted of this offense and sentenced to a term of incarceration, imprisonment, once you complete that term, the adult parole authority does have the right, if they choose to exercise it in their discretion, to put you under what's called post-release control supervision for a period of up to 2 years, which means you would be supervised by a parole officer by the terms they set. The judge is not involved with that. If they do that and they determine that you have not complied, then they have the right to return you to prison as a sanction to serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half of whatever prison term was imposed by the judge for all violations. However, if you're convicted of a new felony while under post-release control, then in addition to whatever sentence a judge in the new case could impose, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
Now, as I indicated, there's a presumption of prison for this type of offense, but it's not mandatory. And so under the law, I can grant what's called community control, or what most people know to be probation. And what that means is that instead of being sentenced to prison, you would be put under the supervision of a probation officer for a period of up to 5 years under the terms set by the court. In the event that the probation department felt during that period that you were not compliant, they would file a written notice of that with the court. You would get a copy. There would be a hearing. At that hearing, you would be entitled to have an attorney. And if the outcome of the hearing was that you had failed to comply, then at that time, the court could revoke your community control, sentence you to a prison term of up to 36 months, and fine you $10,000. You understand that?
Yes, sir.
All right. Now, the charge in count 26, as currently filed in the indictment, alleges that on or about May 19, 2022, in Highland County, Ohio, Justin Kyle Anderson, you, Bridget M. Brooks, Aubrey G. Utley, and Richard A. Scouten did knowingly obtain, possess, or use a Schedule I controlled substance to wit hashish in liquid form in an amount equal to or exceeding 400 grams in violation of Section 2925.11 of the Ohio Revised Code. So that's the second-degree felony. I believe that's a mandatory prison term, isn't it, Mr. King? Or
Yes, Your Honor.
yeah. So currently, that's a mandatory prison term of 2 to 8 years as a minimum, to a maximum of half of whatever term of any number of those numbers were imposed, being added by the adult parole authority. Now, the agreement is that it be reduced to a third-degree felony, and so that would be done by reducing the amount, I believe, to 50 to 200 grams. So, do you understand then what the charge is and what the state is alleging you did and and when, where, and how they allege that you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir, I have.
Are you satisfied with his advice and competence in this matter?
Yes, sir, absolutely.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I'm not.
Are you taking any type of prescription drugs that would interfere with your ability to understand what's going on or being said, or questions that are asked of you?
No, sir.
Now, have any threats been made to make you plead guilty here today?
No, sir.
All right, now, at the bottom of page 2, there are a number of lines that are printed in bold that are underlined, which contain what I refer to as the substantive terms of the plea agreement. And I'll read those into the record at this time. Defendant shall enter a plea of guilty to count 32 and count 26 as amended to a felony of the third degree by amending the weight of hashish in liquid form to an amount equal to or exceeding 50 grams but less than 200 grams. State will dismiss remaining counts. State and defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully with the state and task force. Defendant agrees to cooperate fully in the prosecution of all co-defendants, including testimony. Defendant agrees to the forfeiture outlined in count 32 with the exception of the 2019 Dodge Ram truck, which is not forfeited, and defendant agrees to pay a fine, $5,000 fine. Now, is that your understanding of the agreement?
Yes, sir.
And I'm looking at count 32. There are 8 items total, and so item 6 is the one that's being stricken. Now, which of those items is it alleged that Mr. Zuber has an interest in, Mr. King?
Mr. Zuber would have an interest in obviously the truck, which is not being forfeited. The only other would be
the cash?
Portion of that cash, Your Honor, yes.
All right, the cash. The other vehicles don't belong to him.
That's correct, Your Honor.
All right, so basically, if you had any interest in the $20,393 in cash, that's being forfeited. Do you understand that?
Yes, sir.
Okay. Now, has anyone promised you anything other than what I just read to you in order to get you to plead guilty here today?
No, sir.
Under the law, Mr. Zuber, the matter of sentence is up to the judge, not to the parties. So even though there is an agreement between you and your attorney and the state that the sentence ought to be a community control, meaning no prison, that's not binding on the court. And so if you enter a plea of guilty, once I've heard all the information is presented, if I decide that's not the appropriate sentence, I could impose a sentence of between 9 and 36 months in the increments provided by law. I could fine you $10,000, and I could suspend your license for 6 months to 5 years. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir, I do not.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel, and Mr. McMullen was retained to represent you. In the event that you were not able to afford to continue to pay an attorney, the court would appoint one for you at no cost. So the reason I say that is I just want to make sure you're not entering into this plea agreement because you have concerns that you're not going to be able to continue to pay for your attorney.
No, sir, that's not a concern.
All right, thank you. Now, you have additional constitutional rights you must be aware of before I can accept your plea. First of all, you have a right to have a jury trial in this matter. And that means that 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date that live in Highland County. After 12 of those folks are selected, there will evidence be presented, they'd be instructed on the law. And then that jury of 12 would have to decide by unanimous verdict, meaning all 12 would have to agree as to whether or not the state proved the case against you in either or any of the accounts in the indictment. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, In that case, you would have what's called a court or bench trial. That means instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you, your attorney, and anyone else that was present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court will issue a court order that's called a subpoena, and that forces those people to come to court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in the matter, in this case, at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one can even comment about it, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a presumption of innocence, which means that you're presumed innocent of the charge until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to try to prove you're not guilty simply because you've been charged. In fact, under the law, you're not required to present any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof remains upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of each of the offenses charged in the indictment. And that's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed a crime, and it exercised or invoked all the rights that I have just described. Now, if you change your plea today from not guilty to amended count 26 and count 32, that is the opposite of the not guilty plea. That plea admits the allegation in the indictment as amended in count 26 and in count 32. Admits that they're a crime, that you committed that crime. And that plea would waive or give up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or a court trial. Waive or give up your right to confront witnesses against you and cross-examine through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir, I do.
And are you a U.S. citizen, Mr. Zuber?
Yes, sir, I am.
Now, do you have any questions about the charge or the possible penalty, the amended charge in count 26, or the specification in count 32, which doesn't carry a jail or a fine, it carries simply the loss of any right in that property? Do you have any questions about any of that?
No, sir, no questions.
And you understand?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand that the court's not bound by the sentencing recommendation?
Correct, I understand that.
You have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir, I do.
Have any questions about the plea of guilty or what the consequences of that will be if you enter that plea here today?
No, sir, no questions.
You understand?
Yes, sir, I do.
Is there anything you would like to speak with your attorney about before we go any further?
No, sir.
You have any questions about anything that we've discussed here this morning?
No, sir, no questions.
Then it's your decision to withdraw your not guilty plea and plead guilty to amending count 26 and count 32 pursuant to the terms of the plea agreement that we've just gone over.
Yes, sir.
All right, then to the charge in count 26 as amended that alleges that on or about May 19, 2022 in this county, Justin Kyle Anderson, you, Richard M. Brooks, Aubrey G. Utley, and Richard A. Scouten did knowingly obtain, possess, or use a Schedule II controlled substance with hashish in liquid form in amount equal to or exceeding 50 grams, but less than 200 grams. A third-degree felony carrying a possible prison term between 9 and 36 months in the increments provided by law, a fine of up to $10,000, and a license suspension of 6 months to 5 years. How do you plead?
Plead guilty.
And I'm adding to by ink to the indictment the amendment, striking out 400 and inserting 50, and then adding but less than 200 grams. And putting today's date on the indictment. And F3. All right, then as to count 32, which alleges that on or about, the following property was used in a violation of 2923.32A1, which refers to the count 1, or it was used in, intended for use in, derived from, directly or indirectly, or realized through conduct in violation of section 2923.32A1. And any interest you have is subject to forfeiture, and it's agreed that that would apply only to item 2, $20,393 in U.S. currency. How do you plead?
May I speak with my lawyer separately, please?
All right. Well, let's see here. Trying to find the breakout room on this screen. They've changed the... Huh. Oh, here we go. All right, I'm going to put you into this. You are appearing on the screen, and then the audio is coming through the phone. So I'm going to put both of those in. So you may have to, and once you're done, there's going to be a button that pops up that says join the breakout room. You click on that, and then once you're done, it'll say end, and then you'll have to log back in. But it should be a button that'll pop up. Okay. Mr. McMullen's in the breakout room. Mr. Zuber has gone in the breakout room as well. Okay. We go ahead.
Recording stopped.
Back on record.
Back on record, Your Honor.
All right, breakout room has been terminated, and Mr. Zuber and Mr. McMullen are back on screen. Now, we're ready to go forward, Mr. McMullen?
We are.
All right. Then as to count 32, I believe the question was, how do you plead as to the forfeiture of item 2, the $20,393 in U.S. currency?
I plead guilty.
All right, thanks. All right, the court finds that on this day in open court, the defendant was deprived of all of his constitutional rights and made a knowing and intelligent voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. The defendant is found guilty of the amended charge in count 26, third-degree felony, and count 32, the forfeiture specification as to item 2 only. The court will refer the matter to the probation department for a pre-sentence investigation. The bond will be continued. You'll need to contact the probation office immediately, Mr. Zuber, to make an appointment for a pre-sentence interview. The bond will be continued. And we'll set the sentencing hearing for February the 14th at 1 p.m. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, the folks for the 10 o'clock are here, Mr. King.
I'll be over, Your Honor.
Thank you.
On the record.
Case number 21CB172, Hiding County General Health District versus Connie Anderson. Appearing on behalf of the plaintiff is Assistant Prosecutor Adam King. Also, Mr. Webb is appearing as a representative of the Health Department. And you are Connie Henderson?
Yes.
All right. Ms. Henderson was found in contempt of the order that was issued by the court to clean up her property. That was, I believe, on February the 28th of 2022 that order was issued. And she was adjudicated to be guilty of contempt on November 21st and was sentenced to a term of 30 days in jail and to pay the court cost, and was granted the opportunity to purge herself of that contempt by cleaning up all debris, keeping the premises clean and free of standing water, to pay the court cost. So we're here this morning for that purpose. Now, has the defendant complied with the court's order, Mr. King?
It's the plaintiff's position that she has not, Your Honor.
All right. So, Ms. Anderson, what do you have to say about the matter?
Mr. Webb was out this morning and took pictures, and he said it looks very good. And
He said it looks
on the
very
back
good.
side, he said.
Okay, on the back side.
Yeah.
Okay, but what about the rest of it, Mr. Webb?
Go ahead.
There was still a large amount of solid waste and trash on the front portion of the property, but the backside did look good.
All right, so why haven't you got the whole thing cleaned up? I gave you 6 weeks.
I understand that, and I did obviously make a really hard try at it.
Okay. I think I told you before, the law says that, it's your property, but you cannot maintain your property in a way that causes a public nuisance and violates health codes. And so you have to clean it up. And
I understand.
if you don't, this is the second time now you've been held in contempt. So I can give you 60 days in jail. I only gave you 30. Now, why haven't you cleaned it up?
Well, I got sick for one. That was one issue. When I was in court the last time, I ended up in the hospital that day and that night.
Okay, well, that was on the 21st of November.
So, and then I spent some time with my family for the holidays.
Instead of cleaning up your property.
Huh?
Instead of complying with the court's order and cleaning up your property.
Well, I think Mr. Webb was happy with
Okay.
what I got done.
You ready to do your 30 days today, or do you want to get this thing cleaned up?
I want to get it cleaned up.
All right. So how long do you think that it's going to take you to do that? I'm going to give you one more chance.
Okay.
How long?
It shouldn't take that long.
It shouldn't. No, it should have been done. Absolutely. All right. I'll reset the matter for hearing, for purge hearing on January the 18th. At 11 a.m.
Okay.
If it's not cleaned up, you can expect to go to jail.
Okay.
Because, this is getting to be a pattern for you, and we're going to stop it. Or you're going to go to jail. And then when you get out, you're going to be right back here if you don't clean it up, and you go to jail. Legally, I have the power for an order like this to put you in jail and keep you there until it's cleaned up for up to 6 months, and then start it all over again. But I follow the pattern of 30, 60, 90 that's provided for in other types of contempt. We're not trying to punish you here. We're just trying to get you to obey the court's order. But you've got to obey the court's order. You need to understand I'm really serious about this. So this is your last chance.
Okay.
18th at 11 a.m. If it's not cleaned up, be prepared to go to jail that day,
Okay,
directly to jail. All right?
all right,
Thank you.
thank you.
All right, this is case number 21 CR 58, State of Ohio versus Michael Kingsolver. And you're Michael Kingsolver?
Yes, sir.
This is a motion to terminate diversion. I did not realize that. So the defendant's attorney needs to be present. And that was
Mr. Wagner.
Mr. Wagner. Is he, do we know where he is?
I'm not sure, Your Honor. I haven't talked to him this morning.
All right, I'm going to take a recess and see if we can get a hold of him. Because on a diversion, it's necessary that counsel be present.
Please.
All right, thank you. All right, Mr. Wagner has appeared in response to the court's contact, so I appreciate that, Mr. Wagner. I have to catch him in the building. Mr. Kingsolver was granted diversion and grand theft of a motor vehicle, 4th-degree felony. And Mr. King was the victim of this, notified of the time, place, and purpose of this hearing?
Your Honor, we attempted to notify the victim via phone. We haven't had any contact with him since 2021. I don't know if his phone number's changed or what happened, but we attempted, but we're not able to make contact.
All right. Well, Mr. Kingsolver, I've got your financial disclosure form here. Everything on this is correct?
Yes, sir.
You're not working?
No, sir.
When was the last time you worked?
It's been about a year.
Why aren't you working?
I was doing home health care was my last job, and I was attached to my client, and he passed off, and I just kind of ain't wanted to pick up a new client since, because I mean I'm an attachable person. I just get attached to people for some reason.
All right. Well, the court will find you're entitled to counsel. Appoint Mr. Wagner to represent you. I have reviewed the diversion notification. And as indicated at the time of the hearing, there's not a right to have a hearing. So the court will find that defendant's diversion is terminated, and the court enters a guilty plea or a guilty finding. And I'm going to order an updated PSI, and we'll set the matter for sentencing on February the 14th at 1 p.m. So you'll need to talk to Mr. Arzima about your pre-sentence interview, and bond will be OR only, which is your promise to appear. If you fail to appear, you could be prosecuted for additional felony. You also have to pay a deposit of $171 for service fees within 30 days. All right. Anything further, counsel?
No, Your Honor.
Yes, sir.
All right, thank you.
That's your man right there. All right.
Okay, it's case number 22 TL965, which is tax lien. Ohio Department of Taxation versus Brandy R. Phillips. You're Brandy R. Phillips?
Correct, sir.
All right. It looks like the tax department obtained a lien on August the 12th, 2022 for $2,643.97. They filed a garnishment on December the 4th, and Ms. Phillips indicated that she's waiting on her SSA to send W-2 so she can file. So are you receiving Social Security disability?
No, Your Honor.
Okay. All right, with SSA as Social Security Administration in it?
Correct, sir.
Okay.
Your Honor.
What is the
The format that the IRS sends the W-2s is not the correct format, or not the format that the people filing the taxes can use. All the numbers are in the wrong columns, I guess, for them. So the W-2 that they need is the actual W-2 that you get from the employer, and my last resort is to get it from the Social Security Administration. So since our last court date, I have sent them a letter and a check to get a hold of that W-2 so that I can file.
What, to get the lien, what are you saying, that the lien is not valid? Or is for the wrong amount or something, or what are you saying?
They, the lien is from not having filed state taxes for 2017. Ohio thinks that I need to file for them. It's not for them, I have to file for Kansas, because I wasn't living in Ohio in 2017.
Oh, I see. So you're trying to get the lien lifted. Okay. Well, that's not a basis for, see, the garnishment is they're trying to collect it, and under the law, there are certain exemptions, but if you note on the note, I cannot hear any objections to the actual judgment itself.
Correct.
So,
I believe you told me that last time.
Yeah.
You just
All right.
denied them the garnishment since they weren't here.
okay. So I'm gonna have to overrule your objections, and then, you know, hopefully you'll be able to get that information to show them. This is not the first time I've heard of that. You know, you would have, there is a means of challenging that legally, but you haven't done that. I can't tell you how to do that because that's legal advice. I'm not permitted to give it. It sounds like you're trying to pursue something. So in the meantime, if they collect from you and then it later found that you didn't know it, I guess they'll give it back to you. But unless you pay the 10% or whatever it is they're asking for, they're going to be able to you know, levy.
Come
it.
after me again. I know.
Right. Okay. Thank you.
Thank you.